Now, one minor housekeeping matter on this side, it occurred to me to look in the Contributory Negligence Act at the definition of fault applicable to Scotland. And you've now got it. You can see what it says. Yeah. There are two possibilities. One is that, well, as far as I can see, there are two possibilities. One is that the Scottish provision is meant to have a significantly different effect from the English one, which no one that I'm aware of has ever suggested. Or alternatively, the reference to tort in the English definition, where the Scottish one refers to damages, may be not intended to confine you to a particular cause of action, but rather to demonstrate the standard of what amounts to fault.
Yes, yes. Well, my Lord, that's certainly very interesting.
I'm sorry to spring this on you at the last minute, but it's really something more for Mr. Smith to deal with than perhaps you need to.
It's another shock from north of the border.
Yes, I'm afraid so.
Very interesting. My Lord, we'll think about it during the course of the day. My Lords, just to pick up two very short points from yesterday, but both just on section 37, the agency limitation argument. My Lord, Lord Reid noted that Sefton is in the official law reports. Yeah. We've got that in the bundle. It's MS 4807. I'm not sure why there are two versions. 2 points on the construction of agent in section 37. My Lord Sales put to me an argument made by Primeo at paragraph 97 of its reply case, that Bilmwith was an agent in the sense that it could affect R2's relationships with Primeo, because if it failed to perform its custodial duties, R2 would incur liability to Primeo. And in that context, I referred you to the discussion of the meaning of affect legal relations in Bousted, but I didn't have the bundle reference, and that is supplemental bundle 2 at page 266, and it's chapter 1, paragraph 4. And affect legal relations means power to contract or transfer or dispose of property or similar powers, not merely doing something for somebody else. If affect legal relations was given the wider meaning suggested by Primeo, all independent contractors would be agents and detract the customary fiduciary duties. And that's not the law, as Bousted makes clear. So we submit that this point doesn't assist my learned friend in bringing Bilmwith within the established meaning of agent. Also, in response to my Lord Sales, I submitted that it was consistent with the policy of the statute for the draftsman to draw the line for the purposes of limitation where it is drawn at common law, namely that the agent's fraud is generally treated as the defendant's, but not so far as non-agent contractors. And that reflects the relationship between principal and agent and the duties owed by agents, but not mere contractors. We addressed the comparison with the common law at paragraphs 283 and 4 of our case and the policy. And I wanted to note that as regards Primeo's response at paragraph 104, which is at page 2345, it doesn't meet the point. The fact that a contractor may remain liable for defective contractual performance by its subcontractor does not mean that he will be fixed with the fraudulent conduct or the state of mind of that subcontractor at common law. We do say, as here, as in other places in Primeo's submissions on this point, they tend to run together the defendant's liability for contractual performance by its subcontractors and its liability for the subcontractor's fraud. And in our submission, it's important to keep those 2 points separate. My Lord, if I can now pick up where I left off yesterday, and I was dealing with our appeal on administration, and I indicated I had 3 points that I wished to highlight. I dealt with the first, which was the judge's conclusion that multi-source reconciliation was the sine qua non of a competent administration. It was not supported by Ms. Bader's written experts' reports and is not consistent with the principal functions of administrators. The second point, which I'm moving on to now, is our first primary criticism against the SICA decision. SICA said that they would deal with that point about multi-source reconciliation in its judgment on the post-April 2005 period, and it never did so. We can see at SICA's judgment at paragraph 284, that's page 282, that is what it said it would do. But if you look at the paragraphs on the post-April 2005 period, which we have at paragraphs 285 to 302, it didn't do so. And it ought to have done so in our submission, because the judge's error on this was of foundational importance, affecting his view of gross negligence post-April 2005. My Lord's, coming to my Lord Reed's observation in respect of Debbie and Roy, in our submission, this doesn't raise any question of challenging a second concurrent finding of fact, because the point is SICA didn't actually deal with it. The third main point, and I'm sorry I have to deal with this at such speed, is that SICA was wrong to find gross negligence post-receipt of the KPMG report. And the basic point we make is that neither the judge nor SICA asked the right question of themselves on the right premise. And the right question is whether, as a matter of professional judgment, could a reasonably competent custodian have concluded that it was appropriate to continue with single-source reporting post the KPMG report. Now, both the trial judge and SICA approached that question, if it did, on the wrong premise. We see that from the judgment at paragraph 230, and that's page 129, where the judge says that the report did not justify the continuation of, quote, a flawed process. In other words, failure to adopt multi-source reconciliation. So we see that at paragraph 230 of the judge's judgment. And SICA adopted the same approach. And we see that in the SICA judgment at paragraph 300, at page 287, they adopted the same reasoning as the judge, and we can see in the last sentence of that paragraph, they were again focusing on the failure to adopt multi-source reconciliation. So, my Lord, again on the Debbie and Roy point, we say that we're not asking the court to review concurrent findings of fact. If the court had asked itself the right question on the right premise, we say that the answer is yes. Post the KPMG report, a competent auditor exercising his professional judgment could conclude it was appropriate to continue with single-source reporting. And we say that just very briefly, that because everybody knew that they couldn't get confirms direct from third parties. Everybody knew that instead of the auditor taking control of getting the confirmation, putting it in auditing terms, they were getting the confirmation from Madoff himself. So everybody knew that Madoff was producing the copies of the DTC documents, but the complexity of those documents was such that no one thought that they could be forged. Sorry, I've occasionally said auditor when I should be saying administrator, but I'm sure. Please apply the Manai approach to construction.
If I can, on that, I mean,
yes.
Why wasn't it a possibility to go, for instance, to Bank of New York? Because as I understand it, at each month end, Bilmis was representing that it had converted everything into equities and so on, which would be held in account, treasury notes, which would be held by Bank of New York, for example.
But then it was still the global account, and there were confidentiality concerns that might arise. I think that was the question.
Right, but as I understand it, Bilmis was representing that the Primeo notes were held in segregated accounts. So why could that not have been checked?
Segregated from Bilmis's proprietary trading, but not segregated in client accounts for the individual underlying clients. So there was only a single account as between Bilmis and R2. It's what was described as being the omnibus account. So it was only an omnibus account.
I'm so sorry, I'm not quite following. It was represented that there was a single account between Bilmis and R2. Is that what you're saying?
Sorry.
If that's so, that could have been checked.
I'm sorry, no. At the Bilmis level, there was only an omnibus account for all of Bilmis's investment clients. And so at the Bilmis level, there was no, all client assets were said to be held in a single omnibus account.
Which was segregated from what?
Which was segregated from the proprietary business that Bilmis was doing. Because that's one of the points. Bilmis had a legitimate broker-dealer business. So Bilmis was actually making hundreds of thousands of transactions a day through DTC, but in relation to its broker-dealer business. So there was an omnibus account that separated the proprietary business of Bilmis on the broker-dealer side from the investment side for its customers. But on the investment side, it was the omnibus account.
Thank you.
So, my lords,
I'm sorry, I know you're tied for time, but I'm struggling with a similar point to that which Lord Sales is making, and that's this. I mean, in order to satisfy KPMG, Bilmis produced a lot of DTC documents. Other than Mr. Madoff's wish for confidentiality, is there any fundamental reason why one couldn't have gone to DTC to get those very documents which have been forged?
Yes. And my lords, we had an awful lot of evidence in relation to this. And DTC will only provide information to certain specified people. So to the client, the dealer who's registered with DTC, to the auditor, and to the SEC. And the structure of DTC all flows out of, and we had lots of expert evidence on this, the paper crisis from 1974, where they had to move from materialized securities to dematerialized securities. And as part and parcel of that, DTC was set up in such a way that it wouldn't communicate with underlying clients, because otherwise it would be swamped by requests for information. And so, my lords, we'll dig up the expert evidence identifying who actually had the rights to approach the DTC.
Yes,
and it was limited to 3 categories of persons, as I recall. And so that's why those who knew about these things, including KPMG, that they recognized that they were not going to be in a position to get direct confirms from DTC.
Without Bilmis's authorization?
Even with Bilmis's authorization. So, my lords, what we would say is...
test it for them.
Sorry?
Bilmis could get it for them. If they said, if KPMG said to Bilmis, "We need to see this. Will you get it?" They could refuse, obviously, but they could authorise DTC to release that information to them, and thereby.
Yes, but I think that was all sort of part and parcel of why people, the inability or Madoff's refusal to give that authorization would not excite suspicion, because Madoff would just simply say to these people, I'm sorry, you don't understand how DTC operates. I'm one of the founders of NASDAQ. They don't provide information directly to third parties. My Lord, what we would say is test it in this way. When KPMG produced their fraud review, their report didn't say, putting it colloquially, it's not worth the paper it's written on, because we did not get the confirms directly from the DTC, and that creates a major risk of fraud. So just like the SEC, everyone thought that the complexity of the documentation obtained on spot inspections, and this is the De Pascali evidence, they thought that the complexity of the documentation that they were seeing meant that there was no significant risk of fraud. So as I said earlier, it's not a case like Leeson and Barings Bank, where you're just looking at one document, which is a fax, and it's been copied and pasted. And we'd invite your lordships to look briefly at the De Pascali evidence. It's referred to by the judge at paragraph 11 of his judgment at page 17. The transcript of Mr. Pascali's evidence in criminal proceedings in America is at Supplemental Bundle 1 at pages 75 to 86. I can guarantee to you it's by far and away the most interesting thing you'll read in the context of this case. It explains how Madoff duped KPMG. It explains how the daily SEAC reports, which were the DTC documents, which KPMG, taking a random date, not notified in advance, asked to see the documentation in relation to. An hour and a half later, or 2 hours later, the pile of documents standing 3 feet tall was provided to KPMG. And if your lordships read the transcript, you'll learn why this evidence was called the refrigerator evidence during the trial. So my lord, that's why we say that if the two courts had concentrated on the correct question, they would have concluded that a competent auditor exercising professional judgment could have properly concluded that after the KPMG review, although they knew they were not getting information directly from the DTC, nobody was contemplating that this fraud could have been committed. And that's one of the reasons why Judge Frey was saying it was a fraud of historic proportions or complexity. My lord, two very quick points now. Assignment. We deal with assignment at paragraphs 302 to 319 of our case, and we rely upon what we say there. 2 quick points. First, to emphasize that the assignment issue only arises if you are against me on the finality of litigation issues. The second point is that we're not asking the board to decide the assignment issue. If you are against me on the finality of litigation issues, the assignment issue is just one of the issues that should be added to the long list of matters to be remitted for further hearing. And drawing up that list of matters that are remitted would be no easy thing. In response to my learned friend, and picking up the point that my Lord Reid made yesterday, that many of these issues had already been considered by Mr. Justice Jones and he'd given his decision. In response to my learned friend's reply in his reply submissions, The fundamental point that Primeo's response fails to grapple with is that Primeo was, on the face of it, getting full value under the Herald transfer. It was getting 100 cents in the dollar for the bill missed manage account assets in terms of the nominal value of Herald shares. And that, in our submission, is the key driver for why there was necessarily an implied assignment of Primeo's rights against R1 and R2. And it's in that context that we rely upon the principle behind non-derogation of grant and fair dealing. My Lords, the last matter, which is...
Sorry. Just pick up on this.
Yes.
You say that you asked for a remittal of that issue. Was that an issue that was pleaded and gone into in evidence at trial?
No.
So the finality points would count against you on that?
I'm very concerned not to be misunderstood on this. To be crystal clear, I am not asking you to make a remittal.
No, I understand that,
yes,
but I'm covering the logical possibility, query practical possibility, that we say remit some issues for the benefit of Primeo, and then you say, well, add this one on, but the finality points you made yesterday would count against you on this.
All we are saying is, if we have so misunderstood the law or the principles in relation to finality of litigation, that Primeo's issues are to be remitted,
right,
despite the fact that they weren't pleaded, evidenced at trial, no submissions made, we would have thought by necessarily logic the assignment issue would fall into the same category.
Yes, thank
we
you.
say it doesn't. We say the principles of finality of litigation are completely wrong. I don't want my learned friends to be suggesting I myself am asking the board to make a remission. I'm not.
I understand.
My Lords, the final point, the capacity in which the loss was suffered, this is the final ground of our appeal. We rely upon what we said in our case at paragraph 320 to 333, and the main point that we are making here will already be understood by the court. If we're right on our NI-credit argument, Primeo suffered no measurable loss pre-August 2007. It suffered its loss in December 2008 on the collapse of Bilmis, and the boards held that the reflective loss rule operates by reference to the date of loss. That's your Lordship's reflective loss judgment at paragraph 62. That's page 408. And at that date, Primeo was a shareholder of Herald, and so the claim against R2 was for reflective loss and is therefore barred. My Lords, I sensed a certain resistance to my submissions on NI credit, but we do submit that if the sicker reasoning is right on its use of hindsight, if it's right on its analysis of use of hindsight, it must follow that the House of Lords decision in Law Society and Sefton is wrong. That's our submission. If not, we suggest that clarification would be required to explain how those two cases sit together and provide a practical and clear approach to defining when actual loss is first suffered. And of course, that is an issue of critical importance to when limitation starts on the running of tort claims and thus on questions of limitation, as one sees in Sefton itself. So it is an area where it's critical that the law should be clear. And as we say, at the present time, we say there's a very difficult conflict between those two decisions. My Lords, the other point we want to make, and this is my last point, we should emphasize that, in our view, Primeo has still not explained how it can say it suffered loss in circumstances where it maintains it could have withdrawn at any time up to December 2008. Putting it very simply, how can you say you suffered a loss on a Tuesday when you can still withdraw on a Wednesday? And from that, we say it follows that loss was only first suffered when Primeo lost the opportunity to withdraw, which was December 2008. Is there anything else? My Lords, I've run over even my extended time, but unless there are any further matters, those are our submissions.
Well, thank you very much, Mr. Gillis. Mr. Smith.
Thank you very much, my Lord. I'm going to deal, first of all, if I may, with some reply points on our appeal, and then I'll turn to deal with my learned friend's cross-appeal. So going back to contributory negligence, the question, it seems a long time ago, I know, the question of whether Section 8.1 of the Cayman Act applies to contractual claims, including where there's concurrent liability in tort. The first point is my learned friend said it's necessary to look at the nature of the conduct, not at the causes of action. The suggestion, as we understand it, appears to be that it's sufficient to satisfy the definition of fault for the purposes of enabling apportionment in relation to a contract claim if the plaintiff's conduct would have given rise to a defence of contributory negligence if the action had been brought in the tort of negligence. Now, in other words, if you have a contract claim, but the plaintiff's conduct would have given rise to a defence of contributory negligence in a negligence claim arising out of the same conduct by the defendant, then that's sufficient, as we understand the argument as it's put. Now, in our submission, that is inconsistent with the approach and analysis of the House of Lords in Standard Chartered Bank case, the first case I took your lordships to when I opened my submissions. My learned friend didn't spend, I think, much time, if any time, on Standard Chartered Bank. But in our submission, it shows, your lordship, that the focus is on whether contributory negligence is a defence to the cause of action actually asserted and in respect of which apportionment is sought. In that case, as I explained, the cause of action was in deceit. But for that reason, the House of Lords plainly didn't regard the fact that contributory negligence might have been a defence to an action arising out of the same facts in negligent misstatement as providing a basis for the application of the apportionment power in relation to the action in deceit. They looked at the cause of action actually being asserted and in respect of which apportionment was being argued for and asked oneself, well, is contributory negligence a defence to that action? They didn't say, well, look, here's a statement by the defendant. It could have been it could have given rise to an action in negligent misstatement. If it had been put in negligent misstatement, the plaintiff's conduct would have been a defence in contributory negligence and therefore the apportionment power applies. So I do submit that Standard Chartered Bank provides the analytical framework. In our submission, it's inconsistent with my learned friend's argument. My learned friend didn't deal with the point also that if his argument was right, it would mean that apportionment would apply in relation to any cause of action where the relevant conduct was also capable of giving rise to a claim in negligence, and the plaintiff's conduct would have amounted to contributory negligence as a defence for the purposes of such a negligence claim. I mean, it seems to us that if he's right, contributory negligence and the apportionment power would apply wherever you have a set of facts that are capable of being said to give rise to a negligence claim, irrespective of the cause of action that is actually being asserted. And again, it seems to us not only is that inconsistent with the Standard Chartered Bank case, it's a rather surprising conclusion and a rather surprising test for the application of the apportionment power. It's irrelevant in our submission that Standard Chartered Bank concerned an action in deceit. What matters about that case is what it tells us about the way in which one goes about the exercise of working out whether the section and the apportionment power applies.
I haven't read the case, and beyond what you've taken us to, yes. It just occurs to me that there is a long line of cases to the effect that in a case concerned with fraudulent misrepresentation, or deceit, it doesn't lie in the mouth of the defendant to complain that the plaintiff didn't take adequate care to detect the deceit.
Yes, and Lord Hoffman does deal with that. There's the principle, I think it's Reddington and Hurd, that again, it goes to the question of reliance. But and I think this is the final sentence of paragraph 17 of Standard Charters, he makes the point, though, that there may nonetheless be other forms of contributory negligence that apply in relation to certainly a claim for negligent misstatement. If we go to... He does deal expressly with this. If you go to, yes, it is final sentence of paragraph 17, so E6690. I think I said Reddington and Hurd. It's the rule in Redgrave and Hurd. And as he says, as Anthony Evans correctly pointed out, the rule in Redgrave and Hurd applies to both innocent and fraudulent misrepresentations. As a wider rule, he identifies from a case called Edgington and Fitzmaurice, applies only to fraudulent misrepresentations. And it's quite right that contributory negligence within the Redgrave and Hurd principle isn't a defence to a misrepresentation, misstatement claim in tort, but other kinds of negligence might be, because that's the point he makes in the final sentence of paragraph 17.
Yeah.
So he does, in our submission, actually recognise that point, and he expressly recognises that there might actually be forms of contributory negligence available as a defence to an action framed in negligence. But the whole focus of that doesn't matter to his analysis, because the whole focus of his analysis is looking at the cause of action that's actually been asserted and asking oneself, well, is contributory negligence a defence to that action? And that's what you get from, the nub of it is in paragraph 18, because he then says, well, effectively what really matters is that in relation to fraudulent misrepresentation, deceit, there is no common law defence. It doesn't matter what the position is in relation to negligence, and it follows that no apportionment under the 1945 Act is possible. So, that's what we say about that, and we do, obviously, as our starting point, fundamentally pray and aid the analysis in the Standard Chartered Bank case. I think at this point it's perhaps helpful for me just to comment on Section 5 of the Law Reform Contributory Negligence Act, because that probably fits in at this stage in the analysis. I think there's 2 points I would make about that in relation to the definition of fault. The definition of fault, as in the English and the Cayman provisions, obviously has the 2 limbs to it, and I think it's recognised that the first of those focuses on the conduct of the defendant, the second limb focuses on the conduct of the plaintiff. So far as the first limb is concerned, I would note that the language there is rather different, both from the English Act, but in particular from the Cayman Act. The Cayman Act refers to an act giving rise to a liability in tort, specifically, which is rather different language, I might say, to the Scottish provision. But secondly, in any event, in relation to the Scottish provision, you have the same second limb focusing on the plaintiff's conduct, or would, apart from this act, give rise to the defence of contributory negligence. So far as the plaintiff's conduct is concerned, you still have to ask yourself, well, apart from the act, would the conduct of the plaintiff have given rise to the defence of contributory negligence? So in my submission, the same analysis from Standard Chartered Bank would apply in relation to that as well. You're asking yourself the same question. Look at the claim, ask oneself, if the act wasn't there, would contributory negligence be a defence to that claim?
Yes, but obviously the argument is that under Section 1 there has to be, in the first place, fault on the part of the defendant, and in that, and the English provision, which then gave rise to the Cayman provision, obviously defines fault in that context, using by reference to acts put shortly, which give rise to a liability in tort.
Yes.
And the argument is, well, that indicates that the cause of action against the defendant lies in tort.
Yes.
And obviously that is a more difficult argument in relation to the Scottish provision, because wrongful act is giving rise to liability in damages is a wider expression.
Yes.
And so one's left wondering whether a wider meaning was intended north of the border, or whether the cause of action interpretation of the English of Section 4 is perhaps not the right way of reading Section 4.
Well, I mean, I think that the 2 points are, so far as the English statute is concerned, focusing on defendant's conduct, I mean, it is, I would submit, relatively clear and unambiguous in that it's focused on the position in tort. I mean, the only way you can get there otherwise is to read negligence disjunctively, which was effectively the approach taken in the New Zealand cases. I mean, that's obviously wrong, I submit, and I think my learned friend isn't advancing that argument. You have to read it conjunctively. If you read it conjunctively, it's negligence giving rise to liability in tort. That's obviously reflected in the way the Cayman draftsman understood it, because when he shortened that formulation into the Cayman provision, he encapsulated it in the words "an act giving rise to a liability in tort." So, I mean, that's clearly how he understood that provision. But the other point I would make is, apart from that, our argument is really focused on the plaintiff's conduct and what the legislation tells you is the qualifying characteristic of the plaintiff's conduct. And it's those words must give rise to the defence of contributory negligence apart from this Act.
Just on paragraph 18 in Standard Chartered.
Yes.
I mean, I wonder whether the real explanation for that is in Section 1 of the 1945 Act, which, can you bring that up for me? 6. And it's Section 1.1. It was the point we debated when you were opening the case, that there seems to be, or arguably may be, a connection between the availability of a defence of contributory negligence as at 1945 and the circumstances in which the equitable adjustment applies.
Yes.
But then, if in 1945 it was contemplated that in concurrent cases of contract and tort duties of care, contributory negligence would apply, it would follow, wouldn't it, that the equitable adjustment could apply in those sorts of cases, but would not apply in the deceit case?
Well, I wouldn't agree with that, I think, because fundamentally you go back to the legislation. What the legislation is saying is, to the extent contributory negligence was a defence in tort, to the extent contributory negligence was a defence to the particular cause of action, then that is removed as a defence, but the quid pro quo for that is the conferral of the apportionment power. But you still have to ask yourself, well, what is the position apart from this Act? Now, if it's right, and this is the second part of the argument, if it's right that apart from the Act, contributory negligence was a defence to a concurrent claim in contract, if that's right, then it follows that Section 1 would apply, because the test for the application of Section 1 is to ask oneself, is contributory negligence a defence to that particular cause of action? If, on the other hand, contributory negligence wasn't a defence to a concurrent claim in tort, there's no need for Section 1 to apply. You don't need to remove the defence, and there's no basis to apply the apportionment power. So it just takes one back to fundamentally to the same inquiry, the same simple question, which is, but for the Act, was contributory negligence a defence to this claim? That's how that's our submission.
But the reason for me raising it is that interpretation would be consistent with, when one comes to the meaning of fault in Section 4, interpreting it as imposing a standard of conduct rather than incorporating in itself, in Section 4, reliance on a particular cause of action.
Well,
I mean, in the sense it wouldn't need to, on what I'm putting to you,
yes,
because the cause of action point would be covered by Section 1.
Yes,
so that
exactly.
does beg the question, as you say, of
yes,
what was understood to be covered by a defence of contributory negligence in 1945.
Exactly. I mean, that's the fundamental question. What was contributory negligence to defence this particular cause of action? And I mean, to cut ahead, I mean, the legislature didn't in 1945 have to concern itself with identifying all the particular claims to which contributory negligence was a defence. All it said was, to the extent contributory negligence is a defence, it's removed, and you get your apportionment power. The legislature didn't have to sort of produce a tick list of this is a cause of action to which contributory negligence applies, this is one that doesn't. It was just saying to the extent it does apply, we're removing it, and the quid pro quo for the removal is the apportionment. Now, fundamentally, it takes you to, and this is my next point, which is, in our submission, the nub of this, which is whether prior to the 1945 Act, contributory negligence was a defence to an action in contract where there was concurrent liability in tort. Now, my learned friend referred to Lord Justice O'Connor in Vester and Butcher, firstly, and this is at 4125. I think he intended to refer to 867D. And the sole case he refers to is a case called Adams against Lancashire Yorkshire Railway Company. It's a railway passenger case involving a defective door in a train. We have that in the bundle. It's a case where the claim was put of one of negligence. It doesn't make any reference to contract at all. And indeed, Professor Williams, Glanville Williams, who's I think perhaps the lone person who takes a contrary view in this area, accepts that the cause of action wasn't framed in contract. That's at footnote 1 on E9862. So, we respectfully submit Adams doesn't provide support for the proposition. My learned friend also referred to Lord Justice Beldam in Barclays against Fairclough at E3045. And he referred, I think, to the passage between E and F. And he said, examples frequently cited are claims for damages against an employer or a passenger against a railway or bus company, where the plaintiff may frame his action either in tort or contract. And the duty relied on, in either case, is a duty to take reasonable care for the plaintiff's safety. Contributory negligence has been a defence for such action for many years. Now, he doesn't cite any authority anywhere for that proposition. I mean, it may be it's a reference to Adams against Lancashire and Yorkshire Railway Company. If it is, in our submission, it doesn't take matters much further. He certainly doesn't identify any case law that supports that.
But we have to bear in mind there may not be a huge amount of case law,
Yes.
but claims for personal injury were the bread and butter of the bar.
Yes.
When somebody like Lord Justice Beldam was a young barrister, and he'd have learnt how to plead these claims,
Yes.
and how to plead the defences, and there would have been, there's a lot of experience will lie behind.
There are, but I mean, maybe you have a lot of cases like the example cited, which is Adams, which are cases where the action was framed in negligence, and you could say, well, actually, there's also a contractual cause of action there because money was paid, but actually, the action is put as one of negligence, and in those cases. You can see from Adams that contributory negligence was regarded as applying. But what the court isn't doing in those cases is grappling with the contractual cause of action. I mean, that is not how the action is put, is not how the action is framed. So ultimately one gets relatively little little support from those cases in our submission, and indeed the one case appears to be Adams.
If my learned friend misheard, the passage that I quoted from Lord Justice O'Connor's judgment was at page 860 at letter D, not 867. So just in case my learned friend misheard.
I'm grateful. Sometimes I think my learned friend's references might not be entirely accurate, but
They are.
Can we go to...
Just before we...
Yeah.
Well, sorry, you check that and
Yeah.
respond to that.
Yeah.
Moved A60D in its investor.
Well, we'll come back to that. I was going to make the third point, which I think the third piece of material which was allowed was the Professor Steele article. Yes, well, 860D doesn't cite any authority at all because if you go to that, it's 4118.
But is it not quite a good point being made that, if contributory negligence, which, as we know, is a complete bar to a claim before 1945, if you had an injured miner, for example, bringing a claim, the mining company had a very he had a very simple way of avoiding that defence, those acting for him, simply by pleading contract.
Yes. But there is no case, I don't think, which deals with that situation. There, there is no case we've been able to find, the other side have been able to find, where you have that fact pattern where you have a contract claim.
We have to be realistic about our predecessors weren't stupid people. If there had been a simple way of avoiding a contributory negligence defence, surely somebody in the course of the 19th and first half of the 20th centuries would have thought of it.
Well, what one can see from the cases we have is cases like Adams, which just put as negligence. It's not putting contributory negligence as a defence. You've got, let's go to just pick up the point on Lord Justice O'Connor now. My friend wants to refer to 860D on 4118. I'm not sure he's actually making a point in relation to the position pre-1945 there, as opposed to the position post the Act coming into force. He certainly doesn't cite any case law. So far as the third source of material relied on by the Professor Steele article, that identifies, I think, Lord Simon, the Lord Chancellor, as being conscious of the risk that contributory negligence might be sought to be pleaded as a defence to personal injury claims put both in tort and as breach of contract to carry safely. This is E10196. It's correct to say he identifies that as a risk. He's not recorded as saying it would be a defence to the contractual action. And what he appears to be concerned about is to remove the risk that this might be argued. And in our submission, that is actually consistent with how the legislation works and was intended to work, because what it's saying is to the extent contributory negligence was a defence to any cause of action, then it's removed. But the legislature, and indeed Lord Simon, don't need to identify whether it was in fact a defence to any particular cause of action. They just adopt the formula, which works perfectly well from their perspective, that if it is a defence, then it's removed and the quid pro quo is apportionment. Now, my learned friend also advanced no reasons at all why the Australian High Court's consideration of this point in Astley and Oztrust was wrong. They, in our submission, considered the point carefully in those pages of the judgment I've cited to your lordship, and explained by reference to the source material that we have why it wasn't a defence to a contractual claim, including in a case of concurrent liability. So, my Lord, that's our first point, our first submission in relation to contributory negligence. It doesn't apply at all to a contractual claim, including where there's concurrent liability in tort. Now, if I'm wrong about that, I then move to my fallback position on this part of the case, which is focused on the categorisation of the claim against the second respondent. Now, the first point in relation to that was my learned friend said that our analysis was wrong because we focused on the nature of the duty rather than on the liability. And he relied heavily on the fact that Mr. Justice Hobhouse, in describing category-free investor, used the term liability. That's 4106. Just by letter G, his category 3. Now, there's a tendency, I might suggest, to treat the words of Mr. Justice Hobhouse as if they were a statute. They're obviously not. They can only be a summary of what the Act, in fact, provides for. Now, as I've already explained in our submission, the correct construction of the Act is that Section 8.1 applies where the plaintiff's conduct would have given rise to a defence of contributory negligence prior to the Act. Now, if that's right, then Vesta Category 3, by definition, can only extend as far as cases where contributory negligence was a defence prior to the 1945 Act. Now, as I say, that takes one to the point I've just been discussing. But let's assume for the sake of argument that I'm wrong on that point about whether it was a defence to concurrent claims in contract and tort. That can only be the position in relation to the type of cases that we've been discussing, which were identified by Lord Simon, by Lord Justice Beldam, by Lord Justice O'Connor. In other words, the type of case where there was a coextensive duty, because you have a situation such as a railway passenger buying a ticket to go on a train, a bus passenger buying a ticket to go on a bus, possibly an employee, such as a minor. Now, those are the type of cases where, taking the other side's argument at its highest, the defence of contributory negligence may have applied. Those are all cases of coextensive duties. Now, what there isn't on any view in our submission is any evidence whatsoever to suggest that pre-1945 contributory negligence may have been a defence to a contractual claim where there wasn't a coextensive duty in tort. In other words, to take the point against us at its highest, the best that can be done is to say, well, actually, on the balance of probabilities, contributory negligence might have been a defence in these sort of concurrent and coextensive duty claims. Now, as I say, if that's the right analysis, and we submit it is, Vesta Category 3 is confined to those type of cases, in other words, coextensive duty cases. The fact that Mr. Justice Hobhouse uses the word liability, which is perhaps capable of different meaning, doesn't alter that, because the conclusion is driven by the wording of the statute, the circumstances in which it applies, and the position as it stood prior to 1945. So the bottom line on this is that on any view it's necessary to have coextensive duties to fall within Vesta Category 3. Now, that is not the case here, plainly, in relation to Clause 16b of the Custodian Agreement. The duties under Clause 16b and any duty in tort are not coextensive. And just on this point, one interesting point perhaps to note is that when the Australian legislation was introduced to reverse Astley and Austrust, it expressly requires coextensive duties. If we go to E9169, just as an example.
That's the number again, sorry.
At 9169. So this is an example. As I said, there's a number of pieces of Australian legislation in each of the states. This one happens to be the Australian Capital Territory. I think apart from South Australia, they're all effectively in the same form. But you'll see when it defines wrong, under B, limb B, all that amounts to a breach of a contractual duty of care that is concurrent and coextensive with a duty of care in tort. And in my submission, that is consistent with the submission I've just been making as to how Vesta Category 3 is to be understood. And if you take the case against me on my first point at the highest, it can only go as far as saying Vesta Category 3 extends to coextensive duty cases. So
I notice, I'm afraid I get distracted by pursuing interesting-looking things that we see. In Adams, they distinguished the earlier case of Signer
yes.
and the Great Western Railway. And when you look at Signer, which is another of these cases where you have passengers on a train and essentially the train halts for an indefinite time and eventually the passengers start getting off and yes. one of them is injured in getting off the train. And at the end of the day, it's held that it was her own fault, and so her action is dismissed. But the action was in the Court of Exchequer, and the declaration sought was first that the wife was received by the defendants as a passenger to be carried from West Bromwich to Rhyl, on the terms that defendants should use due care in and about carrying her, etc. So it reads very much like a case based on the contractual terms of her carriage.
Yes, I haven't looked at Signer, I don't think, at least not recently.
No, well, I don't expect you to do so on your feet either.
Yeah.
I'm just.
Because I've been looking at Glanville Williams. Because
yes.
He refers to Bullen and Leake on pleading.
Yes.
And already in 1951, that's the 9th edition.
Yes.
So, I mean, it definitely goes back into the 19th century, and there'll have been other books as well.
Yes.
Which will have told you how to plead a case. A commonplace, workman's liability,
yes.
Rail injuries.
Yes, but I think,
no one's looked at that yet, but...
well, isn't that the point that I think the Australian High Court go through in Astley and Ostrust, don't they? Because they say, well, if you look at the old textbooks on pleadings, like Bullen, it doesn't say anything about pleading and contributory negligence as a defence to a contract claim.
Yeah,
and indeed
they also say there's no authority. But the first case I looked up was the Wilson and Clydes one,
yes.
where Lord Wright seems to regard the Minor's claim as being fundamentally based on contract.
Yes.
And this case of Signer, the railway passenger, it's pled as a case based on a contractual term.
Yes.
Yeah, I mean, the point I was making was more as to how the plaintiff frames their case.
Yes.
Because we know that there are examples of contributory negligence being a defence.
Yes. Well, you see, from Adams, an example of how it's framed, and it's put as, the action is put in quote, negligence, unquote. But, be that as it may, ultimately those cases, if your lordships take the view that actually they do show that contributory negligence was a defence to certain types of contract action pre-1945, in my submission, they tend to support my fallback position on this, which is to say, well, if you look at the scope of VESTA Category 3, it must be limited to those sort of cases, coextensive duty cases. And fundamentally, that's enough for me for the purposes of this appeal, because I then say, well, actually, we're not in a coextensive duty case here, because the duty under Clause 16B of the custodian agreement was not coextensive with a duty of care in tort. So, I mean, that may be quite a long way of getting to my bottom line on this part of the case. Now, the second point is, even if we're wrong about that, and the Court of Appeal, the Cayman Court of Appeal's approach of focusing on the overall liability position, taking into account the exoneration indemnity provisions rather than merely looking at the duty is correct, then we also submit that my learned friend failed to demonstrate the basis for any liability of the second respondent in tort, which would be the same as that liability in contract. So this is now focusing on the other part of the equation, which is, well, what's the position in tort? He referred to Henderson and Merritt, but that merely establishes that the existence of a contract is not a bar to a concurrent duty being owed in tort. It obviously doesn't say that wherever there is a contractual duty, there will be a corresponding duty in tort. Wherever there is a duty of care in tort, and if so, what duty, depends on the assumption of responsibility concept explained in Hedley-Byrne against Heller and the very long line of cases since then. Now, if we look at Clause 16B, which is 449, it's important in our submission just to focus on what Clause 16B is actually doing. What it does is effectively give a permission to the custodian to appoint someone else, an agent, sub-custodian or a delegate, to perform its duties under this agreement. So it effectively says you, the custodian, can appoint someone else to perform your duties. But that if you do that, you must comply with these further requirements, which are set out in the clause. So essentially, it's a mechanic to allow someone else to perform your contractual functions, but if you're going to do that, the quid pro quo is you must comply with these additional duties in relation to that person whom you've appointed. Now, in our submission, what hasn't been demonstrated is why the assumption of responsibility concept in tort would lead to the imposition of anything like a duty in those terms, which would give rise to the same liability for breach. It's very difficult in our submission to see how you get to the mirror of a bespoke contractual duty forming part of a mechanic where a party is permitted to appoint another party to perform its functions under a contract.
But I thought on this part of the case, anyway, as I understood Mr. Gillis's argument, he took us through the passages in the judge's judgment and indeed pointed to the structure of Clause 16B, saying that there wasn't identified a, if you like, direct breach of the duties under Clause 16B. In the particular circumstances, what was identified was that, if you like, there was an overarching duty of care as a custodian, and in circumstances where impediments were found in relation to the fulfilment of the duties in 16B, there was a duty then to make recommendations to Primeo to do something about it, is how I understood it.
Exactly, and that's essentially correct, that he, in relation to the particular duties of Clause 16B on the facts of the case, it was the duty to recommend the imposition of the particular safeguards the judge identified, and we'll come to what those safeguards were.
But then, if I can put the punchline, the punchline was that actually the duty being breached was a duty of care in the particular circumstances that arose, not a direct breach of these duties in Clause 16B.
Well, I'm not sure. I don't think that's in my submission, not how the judge analysed it. I mean, what he said was, and I'll try and find the passage, I think he accepted there was a duty as there obviously is, to implement the most effective safeguards. That is the duty. On the facts of the case, what that required the second respondent to do was to make the recommendation. So it's paragraph 193 of the judgment, I think, page 111. So I think this is what your Lordship has in mind. So as he says in the first sentence of 193, and then in the anti-penultimate and penultimate sentences. But he is tying it back to the language you see in the third sentence of clause 16b. And in our submission, ultimately, what has to be demonstrated is that there is a coextensive duty in tort mirroring that clause 16b duty. Yeah. And the question is, well, why would tort have anything to do with this fundamentally? This is a bespoke contractual mechanism allowing one party to appoint another to perform its obligations under a contract. I mean, how does one, in the law of tort, come to a duty, however qualified, that is in the same terms or reflective of the duty you see in the third sentence of clause 16b? And fundamentally, going back to the point I was making a moment ago, I mean, if you compare this case then with the type of cases to which Vesta Category 3 might apply, the coextensive duty cases, the railway passenger, the bus passenger, the minor, this is far removed in our submission. You've got a situation where the duty is primarily contractual, part of a contractual mechanic, and it's very difficult, in my submission, to identify a mirror duty in tort. Now, my learned friend also referred to the Law of Global Custody book. But
I'm so sorry to pick up, but just on 193, first judgment, paragraph 193, first sentence. I mean, do you have an explanation why the judge bothers to talk about R2's failure being negligent?
Well, it may be that's
just
relevant.
Surplusage on
yes,
your
I mean,
argument?
that probably is relevant because, for the purposes of the exoneration clause, because if you go to 16e, the exoneration clause uses the language of negligence.
Right. Okay. He doesn't seem to be talking about 16e in paragraph 193.
I mean, that's fair enough. But the fundamental point is that the duty is the one you see in the first sentence of 16b. And the question is, in relation to that duty, which is the one that was found to be breached, is there the same duty in the law of tort? And that simply, my friend hasn't come close to demonstrating that to your lordships in my submission. What you've got is a reference to Henderson and Merritt, doesn't establish the point, and you've got the Law of Global Custody book, which, as far as I can see, doesn't talk about the imposition of a duty of care in tort at all. The sections, the additional sections my learned friend referred to, I think, yesterday, are concerned with the position under the Trustee Act 2000. So ultimately, we say that it's not right to regard this as a Vesta Category 3 case for those reasons. Now, I'll move then to limitation, which was our second ground of appeal. The issue is fundamentally, at least as a matter of statutory construction, as to the meaning of deliberate commission in section 37.2. My learned friend said that the decision of the English Court of Appeal in Canada Square was wrong for two reasons, essentially. He said, firstly, it relied on the pre-1980 cases and hadn't given proper regard to the guidance, for example, from Lord Millett in cases like Cave, that you shouldn't go back and look at the old the old authorities. He didn't take you to the passage in the Court of Appeal's judgment where they dealt specifically with that point, which is 3389. Passage 111 of the Court of Appeal's judgment. And this is Lady Justice Rose. She's referred to what had been said by Lord Brown Wilkinson in a case called Sheldon, which you see at the top of the page, and then the comments that were made in Cave, which she sets out at paragraph 110. But as she says, there's a difference between construing Section 32 as if it was still a statutory enactment of the equitable doctrine of concealed fraud, which is what Lord Brown Wilkinson had warned against in Sheldon, with trying to understand and construe the word deliberate, which was used in the new legislation. So what she's saying is what we're not trying to do is simply construe Section 32 as if it was equitable fraud. What we're embarking on the exercise of seeking to establish, seeking to understand, is the meaning of the word deliberate, which was introduced into the new legislation. And in our submission, it's quite clear from what my Lords Lord Reid and Lord Hodge said at paragraph 102 of the FII case, that where interpretation of the 1980 Act raises a question of substantial difficulty, it's both permissible and necessary to consider the previous law. And she sets that out, she refers to that in the final sentence of that paragraph. I should say, for good measure, refers to a number of other cases where regard had been had to the pre-existing law when seeking to understand the meaning of the 1980 Act. So that criticism is wrong in our submission. My learned friend's second criticism of Canada Square was that he said the Court of Appeal had focused insufficiently on the removal of recklessness from the Law Reform Committee draft. Your Lordships might recall he took your Lordships to that part of the Law Reform Committee report where they'd set out at that stage a suggested text for the replacement of paragraph 26. And he said, well, look, that said deliberate or reckless. By the time you get to the legislation as enacted, it simply said deliberate. And I think he was inviting an inference to be drawn from that change. Now, in our submission, if one's going to embark on that exercise, it is necessary to look at what was being said by the Minister to Parliament at the same time, or indeed afterwards. If you go to our case at 22, our first written case at 2282, we've set out at 126 through to 128, firstly, what was said by the Lord Chancellor in the House of Lords, and then also then by the Solicitor General in the House of Commons. I think my friend referred to 126. In our submission, what's of particular interest is 127. It's not intended that the new section should be in any way more restrictive than the present law. And then he refers, in fact, in Parliament to Beeman against Arts, which is the case which I showed your Lordship, where it was dealt with on the basis that recklessness was sufficient. Now, in our submission, and then you see, for good measure, what the Solicitor General said to the House of Commons. Clause 7 is a restatement in modern language of the extension of time conferred where there's been fraud or what is presently known as concealed fraud. And then it suggests that the section should be revised in order to express more accurately the present case law. Now, in our submission, those statements are admissible on a pepper and heart basis because there is ambiguity. They're statements from the minister or the promoter of the bill made in the House of Commons and the House of Lords. But aside from that point, my learned friend can't sensibly in our submission invite an inference to be drawn from the change made to the draft section produced by the Law Reform Committee without looking at the full picture, which includes what ministers were then saying to Parliament. And if you look at those statements, in our submission, it is clear that the intention was not to change the existing law. Now, my learned friend also said that R against G can't be the standard because he said that would import a negligence standard. In our submission, that is obviously not right. First, in order for there to be negligence, you need to be aware that you might be in breach of duty. My learned friend gave the example of a lawyer giving advice and you think you might be wrong. But the duty is to exercise reasonable care and skill. So you're only going to be reckless where you're conscious that you haven't exercised reasonable care and skill. That's what you have to be conscious of, not the fact you might be wrong, but the fact that you have or may have breached your duty by not exercising reasonable care and skill in relation to the advice you're giving. But secondly, and in any event, it has to be objectively unreasonable to take the risk, which is the objective part of recklessness. So it's not the case that it simply imports a negligence standard. That, with respect, obviously isn't right.
Right, just on your formulation of the first limb, you have to be conscious that you haven't exercised reasonable care and skill. I wonder if that's an accurate formulation, isn't it? That you have to be conscious there's a risk that you haven't exercised reasonable care and skill.
You may not have exercised reasonable care and skill.
Almost every time I gave legal advice, I recognised that risk. And you could take that as truth.
Yes. Duty to exercise reasonable care and skill. I mean, I think we strive to discharge that duty, don't we? I think you'd have to be conscious of a risk that you breach that duty to exercise reasonable care and skill, and it is objectively unreasonable to take that risk. That is the RVG test of recklessness. Conscious that you are or may be in breach of duty, and it's objectively unreasonable.
Yes, thank you.
Now, the question whether respondents were reckless, I'm not going to say anything much further about that. The judge did not decide that they were not reckless. In our submission, his findings at 226 to 228 do amount to recklessness in connection with the custody confirmations. He found that the second respondent knew it had not performed its duties under Clause 16b, that it knew that Ernst & Young was unwilling to rely on Bilmis and its auditors, and that the second respondent was indifferent to and seriously disregarded the risk of relying solely on information from Bilmis in those circumstances. That's what he finds in paragraph 228 specifically of his judgment. And in our submission, that does amount to recklessness. On his own findings, they knew they hadn't discharged their contractual duties. And in his language, they were either indifferent to the risk and or seriously disregarded the risk. Now, as I say, if I'm wrong about that, well, he didn't deal with the point, despite being asked to, and it would have to be dealt with further. The final point on limitation is Primeo's knowledge of the facts. My learned friend in our submission conflated in his submissions the question of when a cause of action for breach of contract is regarded as accruing for the purposes of Section 5 of the Limitation Act, with the question of what knowledge is required for the purposes of starting time running again for the purposes of Section 32. It was a repeated refrain in his submissions that loss or damage is not required in order for a cause of action for breach of contract to accrue. So it is. We obviously don't dispute that. It doesn't, however, answer the question for the purposes of Section 32, which, unlike Section 5, does not use the language of accrual of cause of action. That isn't the test under Section 32 or Section 37 of the Cayman legislation. So far as Section 37 is concerned, and perhaps we could bring this up, it's at 9486. My learned friend suggested that the relevant question is whether Primeo knew all the facts relevant to the right of action. And he said that by reference to 37(1)(b). We suggested that in a Section 37(2) case, it's actually the facts involved in the breach which is the relevant test, because that's the formulation used in 37(2) itself. And the effect of 37(2) is to deem deliberate concealment of those facts. So in a 37(2) case, in our submission, it would be facts involved in that breach of duty. But even if my learned friend's right that you apply the language in 37(1)(b), and you're focusing on the question of any fact relevant to the plaintiff's right of action, well, as a matter of ordinary language, in relation to a damages claim for breach of contract, loss and damage is a fact relevant to the right of action. This is far removed from the language of Section 5, talking about accrual of causes of action. It's asking oneself, well, what is any fact relevant to the right of action? Now, as I said in opening, I don't think my other friend has produced a case to the contrary. There is no case which says that damage is not a fact relevant to the right of action for the purposes of Sections 37(1) and 2, where one's concerned with a damages claim for breach of contract. The distinction in cases such as Chief Constable of Surrey against Johnson, which I referred to in opening, and Arcadia against Visa Brands, is between, on the one hand, a fact without which the cause of action is complete versus facts which merely improve prospects of success. That's effectively the way those cases characterise the dividing line. Now, if that is the correct dividing line, then in a case of damages, a case of a damages claim for breach of contract, loss and damage in our submission falls into the first category and not the second. You need loss and damage to complete your cause of action of damages for breach of contract, and it can't possibly be said realistically that it's a fact which merely improves the prospects of success. On the contrary, it's fundamental to your claim, your ability to prosecute the claim, the ability to obtain the remedy which you're actually seeking. Now, on this, finally, my Lord Reid rightly referred to Section 14A of the Limitation Act 1980, which, of course, deals with with latent damage. That is another means by which time can be extended under the Limitation Act. Of course, it only applies to tort claims, so it doesn't provide an answer in the case of contract claims. So that's all I wanted to say on limitation. Then the third ground on our appeal was the question of assumption of responsibility, which also trespasses into one of the areas of the cross appeal, which I will deal with at the same time, like my learned friend, because it's convenient to do so. My learned friend's principal point in relation to this, as we understood it, was to say that Primeo was aware of the judge's comment, was aware from the judge's comments made during the trial that it was possible he would find that custodian responsibility applied from August 2002. And he said correctly that this was Primeo's alternative position in closing submissions. Now, as I say, that is true. The judge did make those comments, and in closing submissions, we sought to cover both bases in terms of the question of when custodian responsibility arose. It ignores the fact that so far as quantum was concerned, the trial was conducted on the basis that custodial liability, if it was to be established, arose from January 1994. Now, my learned friend is correct to say that the cash schedules were agreed, but the point about the cash schedules is they simply do not grapple with the issue of how you allocate redemptions once the period of time is divided up. If I can just show you very quickly the cash schedules, they're at page 93 of Supplemental Bundle 1. Page 93 of Supplemental Bundle 1. And you can see that they're not particularly complicated in concept. They've simply taken a 1st of January 1994 start date and rolled the position forwards from there, and then also looked at a December 1996 start date. Now, that, of course, is a matter of concept, is very straightforward. What it doesn't do, obviously, is begin to tackle with the question of how you allocate redemptions once that period of time is divided up. Now, it follows from that, with respect, my learned friend is entirely wrong to say that the judge could have dived into the schedules and simply added up the figures between August 2002 and May 2007 in order to come up with the net position for that period. That is not what this schedule is attempting to address at all. In order to do that exercise, when you're taking part of the relevant period of time, you obviously need to address the question that arises as to how you allocate redemptions. Now, it was then the respondents who asserted what we would say is the odd position that all redemptions are to be treated as if attributable to investments made within the relevant period. So it's the respondents who put forward the proposition that if you're taking a lesser period of time, you treat it in effect as a silo, and you treat all redemptions occurring during that period as being attributable to all investments during that period. As I say, concrete example, redemption made in September 2002, on their case, is attributable to an investment being made after August 2002. In reality, of course, that is unlikely to be the case.
But if you had an alternative case,
yes.
So your primary case is it's the whole strict liability period, 1994 to 2007. If you're right, the net cash analysis is appropriate. But if you've got an alternative case that says, well, I might be wrong about that, but in the alternative, we're saying there's liability from 2002, and that gives rise to other issues of fact. Why isn't the onus on you to plead your case as to those relevant facts and present evidence in order to make good your case on that alternative basis?
Well, because the alternative basis only arose, as I say, from the judge's approach. It wasn't pleaded by the respondents that their custodial responsibility only arose from August 2002. There's effectively...
But you adopted it.
By closing we had, that's correct.
So it was your case. I mean, if one was being punctilious about the pleadings, one might say, well, if you're going to have an alternative case, plead it out. Well, it doesn't matter what the judge has said in the course of the hearing, but you didn't, and the judge let you do that. But it still was your alternative case.
Yes, but as Sim saying, so far as quantum is concerned, obviously the quantum evidence had gone in pre-trial and addressing the position from January 1994 onwards. And
that's a problem for you, isn't it? If you want an alternative case which involves other factual inquiries, well, why isn't it incumbent on you to make that clear at the trial and make sure that the relevant factual inquiries are conducted at that trial?
Well, because the quantum case had not been prepared by the parties on that basis. So the pleadings, if you look at the two sides of the pleadings, on our case, custodian responsibility had been said to arise from January 1994. On the other side, no custodian...
I follow all of that, but why isn't that a problem for you? You've got the alternative case now.
Well, because the quantum evidence has been prepared by reference to the position of the parties set out on their respective pleadings, and you've got the two. So when one is coming into the trial, one has the pleadings which set out the position of the parties. The quantum evidence is effectively reflecting that position. So on the one hand, January 1994 onwards, on the other hand, not at all. And that's effectively the issue, the point on which the parties have joined issue. The evidence has been prepared accordingly to reflect the way in which the parties have joined issue. And what then happens is essentially the judge comes up with a midpoint between the parties' respective positions, and necessarily the quantum evidence prepared on the basis of the pleadings doesn't reflect that. It was a point that arose in the course of the trial. It was adopted as an alternative in our closing submissions, but plainly there wasn't time to put in further quantum evidence at that stage. So that's how the point arose. Ultimately, the point is, it really goes no further than this, in the sense that the respondents before the Court of Appeal, in light of the judge's findings, take the point, advance the argument that you allocate redemptions in a certain way, and the effect of allocating them in a certain way is to produce a zero net loss figure over the period. Their argument is to say, well, if you treat the redemptions within the silo, that gives you a negative, not less, a negative overall figure. Now, if they want to make that argument, of course, that's fine. But in our submission, we should be entitled to respond to it and say, well, no, that isn't the correct way of doing the calculation. The correct way of doing the calculation isn't that you treat the period as a silo. The correct way of doing the calculation is either Clayton's case or there is a right to appropriate. So and ultimately, if that's the argument they wish to make, we should be, in our submission, be entitled to respond to it. Now, I'll deal with a point out of turn, because obviously this particular point factually encompasses both our appeal on this point, but also the relevant parts of the cross appeal. Now, in these circumstances, in our submission, the Court of Appeal were clearly right to say that as part of the exercise of establishing quantum, the calculation issues, Clayton's case and appropriation, should be dealt with by the Grand Court, which is what the Court of Appeal held. First, once liability had been established, these issues would have to be dealt with. The judge, in his judgment, did not anywhere deal with quantum. He didn't address quantum at all. So it follows, if the Court of Appeal were with us on the question of liability, then there would, as they recognised, have to be a further hearing on quantum. It wasn't a case where the judge had made contingent findings on quantum in the event he was overturned on liability. If there's going to be that further exercise undertaken, it can't be right to proceed simply on the assumption that the respondent's assertion as to the way redemption should be accounted for is correct. The respondents in our submission assume that their analysis is the default position, and it's somehow for Primeo to displace that. But in our submission, the respondent's argument in fact involves a proposition as to how you account for redemptions, and indeed a proposition that is somewhat counterintuitive and certainly at odds with the practical reality. Secondly, we said at this point wouldn't involve any new evidence of fact, so the calculation point in relation to the application of Clayton's case and appropriation. The question whether the account is a running account is a question of law on the facts established by the judge. Appropriation is also a question of law, because our position in appropriation, as we explained to the Court of Appeal, is that there is a right to appropriate the redemptions already received from Bill Myth, and that on the authorities, that appropriation can be made retrospectively, indeed even after trial. And if we're right about that, then there's no need for evidence on this point at all. Now, the third point is, my little friend sought to make a point that the Court of Appeal didn't decide the issues. Well, the Court of Appeal was not in a position to decide the issues, because they hadn't had the arguments addressed to them on the substance of the points, not because further evidence was required, but because they hadn't been addressed on the substance of the Clayton's case argument or the appropriation argument, save for some notes which I think were filed following the hearing. And the Court of Appeal's position, in my submission correctly, was that if liability was established, because the judge hadn't made any findings on quantum, there was going to always need to be another hearing on quantum. And if that's right, then it's correct that this issue ought to be resolved as part of that hearing. And that's what you see the Court of Appeal holding at paragraph 227 of the judgment. Now, in our submission, none of that is in any way contrary to anything that was said in Sainsbury's against MasterCard, which is the authority my little friend referred to. If I could just bring that up at paragraph 404 of Supplemental Bundle 1. And the two paragraphs I just want to refer to briefly were paragraphs 241 and 242.
Give me the page number.
Sorry, it's 404 of Supplemental Bundle 1.
404.
241, second sentence. We agree with Mr. Turner's submission that in circumstances where, one, in a final trial between private litigants to determine their rights and obligations interstate, each side has had a fair opportunity to bring forward all the evidence it wants to bring forward in support of its case. So that's the type of circumstance in which the finality point applies. But then, perhaps more importantly, you'll see from the final sentence of 241 and then in 242, what matters is how the parties have chosen to frame their cases. This is necessary to do justice to the party, so that the party that has won in a fair, and it might be at a very expensive contest, is not deprived of the fruits of its victory, to achieve finality and to avoid the court enlarging the dispute outside the way in which the parties have chosen to frame it. In the adversarial system of litigation in this country, the task of the courts is to do justice between the parties in relation to the way in which they've framed and prosecuted their respective cases, rather than to carry out some wider inquisitorial function as a searcher of truth. Now, that was not the case here. This point formed part of neither party's pleading going into the matter. It wasn't part of how the parties had framed their cases. To use the MasterCard language, it didn't form part of the way the parties framed and prosecuted their respective cases at trial. And Primeo had not had...
I'm sorry, I've got to pick you up on that again. It was the alternative way you framed the case at trial.
By closing, but not in a...
Yeah, by closing, yeah.
Well, we had no opportunity of putting quantum evidence on addressing this point.
You could have said to the judge, we've had a rethink. We want to run this alternative case. We recognise that will involve additional evidence. We apply now for permission to adduce additional evidence to deal with that case, and the judge could have dealt with that.
Well, this would have been at the stage of closing submissions, I mean, the position, the judge did not, in fact, make any findings on quantum at all. The Court of Appeal's position, in my submission correctly, is that if a liability is established, the Grand Court is going to have to deal with quantum. I mean, in my respectful submission, that must be right in circumstances where the judge didn't deal with quantum. Now, the practical question, therefore, is if the Court of Appeal is right that the Grand Court is going to have to deal with quantum in any event, why shouldn't this point be dealt with as part of the exercise of calculating the investments, the net position, which is the exercise the Grand Court, by definition, is going to have to do if liability is established?
Would it require the leading of further evidence?
Well, in our submission, no. I mean, the 2 points that are relevant in relation to this is firstly, is it a running account, which is the Clayton's case point? Well, we have the evidence on the Bilmis account. All the statements are there. We have the account opening forms. We know how it operated. The second point is...
I'm so sorry to ask about this, and I should know the answer. What are the criteria for a running account? I just thought there must be some factual element to be determined. You don't just see an account and say, well, it's a running account, so Clayton's case always applies.
Well, I mean, the obvious example is clearly a bank account. So you've got a single bank account which is continuing over a period of time, and you ask yourself, well, is it a single account to which one has a succession of debit and credit entries over a period of time? Or is it actually different accounts? I mean, if you've got a single account number and a single set of bank statements, in this case security statements, over the period of time, well, that shows you've got a running account in my submission.
Was there any such account? Did it exist?
Yes, the account existed, yes. So
in what form?
Well, the account existed in the sense that there was an account number at Bilmis, and Bilmis produced account statements, which were obviously fictitious because the securities didn't exist, but it effectively represented to investors, this is your account with us. I can't recall off the top of my head the Primeo account number. Yes, we do. If you go to 34 of the bundle, E34.
This is the...
So the main bundle, yeah.
34.
So page 34. It's the top of the page. So there was account numbered 1FN092.
There wasn't in reality such an account.
No, in the sense that clearly all the securities which were purported to be held were fictitious. That's right.
And is there some proposition of law you can refer us to that says that a trading account like this must be equiparated to a bank account and hence as a running account?
I don't have any at my fingertips. We can, for the proposition, the securities account is capable of being treated as a running account for Clayton's purposes. We will seek to identify something.
I'll just say it for myself. It doesn't seem to me obvious that one says, well, here's an account, it's a running account, Clayton's case applies. Then there may be relevant circumstances in the commercial context, which may make that true or not true, which would potentially need to be examined in evidence at trial. You say not.
Yes, and I mean the second point, as I say, is the right to appropriate, which in our submission is a legal point. We either have a right to appropriate the redemption payments, or we don't.
But if you do and don't actually exercise the right, how does your capacity to exercise the right after trial have any bearing on your claim? If you haven't appropriated, how does the point arise?
Well, because damage has not yet been quantified by any court. I mean, we're at a stage, I mean, this is a point I'm going to come to. I mean, this is a case where obviously no order for a split trial was made, but the way in which it has developed, is that the judge didn't deal with quantum. It was recognised by the end of the trial that there would need, on any view, to be some further work by the experts. You see, I think, the references to that in our written case. The judge didn't, in the event, deal with quantum for whatever reason. Perhaps he thought he didn't need to. But the upshot of that is that we are in a situation where, if liability is established, quantum will need to be determined. I mean, that is the practical reality.
I may be misremembering this, and if so, forgive me, but I thought we were shown a passage in the judge's judgment where he specifically said that after 2002, the net cash movements were in Primeo's favour on the running account.
I think your lordship's right. I think there is a sentence that says that, and that.
So if that's the basis on which quantum is to be assessed, he's made the relevant factual findings. I mean, I appreciate you're saying you're not stuck with that basis, but if that is the basis, he has made the findings.
Well, he's taken the figures in. I mean, in order to make that finding, you'd have to make the assumption, which we would respectfully say is wrong, as to how you treat the redemption payments.
Yes, thank you.
He has accepted 2002 to 2007 silo.
Yes.
Yes.
Exactly.
But could I ask just one question? You've referred to the 1FN092 account, which we know is a fiction, but is it in the papers? Can we see it? Or pages from it?
Yes. Is it on the?
Because I'd like to see whether it looks anything like it.
There are certainly statements, and we will find a copy.
Because there'll be statements that purporting to claim that there are securities held for.
Yes, exactly. I mean, so how it worked, I think my Lord Sales averted this point yesterday, was Madoff purported to convert everything into US Treasuries at the month end, and then he would produce a statement that, with the account number on it, that basically showed a holding or holdings of US Treasuries to the account. So I think we have. So we have an example at first supplemental bundle, page 19. I'm afraid it's a little difficult to read because of the way they were produced on striped paper, as well as being. So this is actually this is showing the purported transactions during the month. Do we have one showing the position at the end of the month?
Yes, but it's purporting to show transactions and what the value of the holdings were. Would that be right?
That's exactly right. And
yes, but it's not purporting to say that there is cash of a certain value, which you can have a running account and you pay money in, you pay money out, and you know what the balance is. What it is doing is purporting to say we have these securities for you, and they have this value. I mean, is this anything to do with a running account?
Well, it's showing the movements the purported movements on the trading account, so debits and credits over time to the account which is held in the name of Primeo.
Well, but not debits and credits of cash, but
no, not cash.
No, it's fictional securities are held, and it's purporting to attribute value to those securities.
Well, that's right. I mean, that's what Madoff was doing. He was effectively purporting to hold securities at the month end. He was purporting to hold, as I say, US Treasuries, and the statements he was producing were effectively reflecting that.
What he wasn't purporting to do is claim that there was that the client had delivered cash to him, and he had an obligation to pay that amount of cash out at any particular moment. Which is how a bank account would work. The balance will give the use, will identify the customer's use credit, and as money comes in and money goes out, the figure will change.
Yes, I mean, obviously there was, I think this would be reflected on the statements, cash coming in from Primeo to Bilmis as and when new investments were made, and indeed there'd be cash going out as redemptions were being made. In the meantime, you have purported transactions in securities going on with, at the end of the month, purported holdings in US Treasury bills. But of course, there's cash coming in as Primeo makes investments, and there's cash coming out.
It's not easy to read, but it looks as though it's recording what bear to be receipts of dividends and payments of withholding tax on the dividends.
Yes.
Yeah, so quite. So, I mean, recording various sort of transactions on securities. And then if you go to, if you go to page 32, for example, you can see at the month end what was purported to be held was Treasury bills.
But just following on, if I may, from my Lord Reed's point, that means that it's an account which isn't even dealing with, if you like, fungible things. It's dealing with different entities, sometimes money entities, sometimes entities which are Treasury notes.
Yes, I mean, that's undoubtedly
How does
right.
a running account work like that?
Well, it's because it is a single account in the name of Primeo with debits and credits made to Primeo. So the question.
I mean, if you have an account with some sort of investment company and which is receiving dividends on your behalf, and if aware of withholding tax, no doubt debiting you with the withholding tax on it, you'll get sent a statement every so often, and you can see what the state of your holdings is. But it's nothing like a bank account.
Well, as part of that, I mean, that's part of what that statement would show, but it was also going to show, I would submit, your investment you make in. If you make periodic investments, it's going to show that. It's going to show redemptions and periodic redemptions. That is obviously one part of your account. Now, the question is, when you get a redemption, in Primeo's case, I mean, how do you treat that vis-a-vis the investments? So you've got a securities account showing purported trading in securities, but you've also obviously got to prime the pump, the money coming in periodically, and conversely, cash coming out as redemptions. So it is a running account to that extent. I mean, the fact that the balance of the account is used to trade securities doesn't mean that, so far as investments and redemptions are concerned, you don't have a continuum over time, in my submission.
Well, it sounds as though you're saying really that any record that shows the acquisition and disposal of investments by some sort of investment company acting for you is a running account.
Yes.
Yeah. One would expect that to be a proposition vouched in the book, since that's every form of investment account, of which there are millions and have been for centuries. So.
Yes, I mean,
but you're not showing us.
No, but this is. I mean, I'm not
authority for that.
I know, but I appreciate that. But obviously, we're not. We haven't come before your lordships to argue that point. And I'm not suggesting your lordship.
But you have come before us to say, look, it's open and shut as a matter of law and insofar as relevant fact. Therefore, it should go.
No, I haven't come before you to say it's open and shut as a matter of law. I mean, what I've said is it is to the extent there's a point, it's essentially a legal point. It's not a point that requires evidence.
But unless we know what the legal test is, we can't know that, because it may be actually more mixed, which is what I was putting to you before. The commercial context may may inform how one classifies an account. Now, I could see if you showed us, the House of Lords authority that says every account like this is a running account, well, then the law has shut out the possibility of the facts being relevant. But you're not showing us that at the moment.
No, I don't have that. I don't have that available. I mean, those are our submissions on the claim kit bid. I mean, fundamentally, as I say, quantum. If liability was established, quantum would have to go back, and the Court of Appeal was correct to take a view that as part of that exercise of calculating the position, these points ought to be resolved. Now, on the assumption of responsibility,
I'm not sure. Is this perhaps a convenient moment?
Yes, of course. I had lost track of the time. Yes.
Well, in that case, we'll adjourn for at most 10 minutes.
Thank you.
Yes, Mr. Smith.
Thank you. My Lord, I was going to turn, if I may, then to our response to the cross appeal. And my Lords, I was proposing to deal with the issues in the sequence set out in the Respondents' written case. I know my learned friend dealt with them in his oral submission in a slightly different order, and to deal with them in the order contained in his written case. So starting, therefore, with the strict liability claim, it's said by the respondents that Primeo suffered no relevant loss for which the second respondent was strictly liable.
And just so we can keep a note, because we haven't been given the Scott schedule yet, this is additional ground what?
Yes, exactly.
Sorry, what? It was a question.
Yes, additional ground one. Additional ground one, yes. So I'm aiming to deal with them in sequence. So it should be 1, 2, 3, 4. The exception to that, I think, is remittal on strict liability, which I took out of sequence because it went to the topic on which I was just making submission. So additional ground one, strict liability. Now, in relation to this, the respondent's argument is that the Primeo suffered no relevant loss for which the second respondent is strictly liable, and that the Court of Appeal was wrong to conclude otherwise. In essence, our position is straightforward. We say Primeo suffered loss each and every time cash was sent to Bilmis for safekeeping and investment, but was stolen by Bilmis as part of the fraudulent Ponzi scheme, which it was carrying on for all of the relevant period during which Primeo placed investments with Bilmis. There's no dispute about the fact that Bilmis was a Ponzi scheme. This applied for all of the relevant period of time. That's what the judge held in paragraph 11 of the judgment. And now, as a matter of law, at that point when cash was sent by Primeo to Bilmis, Primeo had in effect swapped its cash for a shows in action against a fraudulent Ponzi scheme. That was the effect of that transaction, and had accordingly suffered loss, because rather than having the cash figuratively in its hands, all it had was a claim against a fraudulent Ponzi scheme, which would ultimately enable it to get back whatever might be realised in due course. Now, that was the analysis that was accepted by the Court of Appeal. We say it's correct as a matter of logic and common sense, as well as being supported by the authorities. Now, the respondents raise a number of different arguments, which I'll deal with in turn. The first comes under the head no recoverable loss argument, which is paragraph 47 of their written, paragraph 147 of their written case, paragraph 6 of our reply case. And as we understand it, this is an argument as to how the relevant counterfactual scenario in the no breach scenario is to be characterised. And in particular, again, as we understand it, the respondents now argue that the relevant counterfactual is one where Bilmis didn't steal the cash of Primeo, but Bilmis did steal the cash of other investors. And on that basis, it's then said Primeo didn't suffer any loss. And that's because even in the non-breach scenario, so the argument goes, all Primeo would have been left with is a chosen action against a fraudulent Ponzi scheme to recover its investment. Now, we make 2 points in response to that. Firstly, in the real world, it's wholly artificial and unrealistic, we suggest, to suppose there could, in fact, have been a scenario where Bilmis didn't carry on a Ponzi scheme in relation to Primeo, but did carry on a Ponzi scheme in relation to all other investors. So the whole concept of a Ponzi scheme, by definition, is that it recycles cash from new investors to pay existing investors as they exit. That is, as your lordships know, the whole raison d'etre of the fraud. So it's very difficult to see how there could in fact be a scenario where Bilmis receives and presumably legitimately invests Primeo's money in bona fide investors, but carries on a fraudulent Ponzi scheme in relation to all other customers. So that's the first point. The second point, more substantively, is we say the argument's simply wrong as a matter of principle. And the reason is that by definition, the no breach scenario must be one where Bilmis is in a position to comply with its obligations owed to Primeo. So in other words, a scenario where Bilmis is able to deliver up to Primeo, when required, the relevant amount of cash or securities purportedly held by it for Primeo. Now, as my learned friend said, Bilmis did not segregate cash or securities held for investors from those held for other investors. It didn't purport to do so. It had separate accounts on its own books, but in terms of the way in which it held securities, purported to hold securities, as my learned friend explained, there was effectively omnibus positions at the depository trust company, DTC, JP Morgan, which was its bank, and also Boney, where the T-bills were held. Now, in circumstances where Bilmis was not segregating cash or securities, it could only be in a position to comply with its obligations to Primeo if it was not carrying on a fraudulent Ponzi scheme at all. Otherwise, it would not be in a position to meet its obligations to Primeo. And in our respectful submission, my learned friend's submissions on this part of the case ignore the relevance of the fact that Bilmis was not segregating assets, that it wasn't purporting to segregate assets, so that in order to discharge its duties to Primeo, it would need to be in a position where it wasn't carrying on a fraudulent Ponzi scheme. So in our submission, the applicable no breach scenario must be one where Bilmis is not operating a fraudulent Ponzi scheme at all. The further point I might add to that, just by way of elaboration, is it's very difficult also to see how my learned friend's argument would work where you're faced with more than one plaintiff. Yeah, because if you have a situation where, for example, it wasn't just Primeo who was before the court, but say 6 or 7 of the other feeder funds as well, and the logic of his argument falls down because he's then positing, I think, a different counterfactual position in relation to each of the different plaintiffs. And in my submission, that obviously isn't a tenable position for the court to be left in. It wouldn't be in a position where it could make any sensible findings at all. So in our submission, that first argument is wrong. The second argument is then to say that any loss suffered by Primeo was rectified by the Herald transfer, which took place in May 2007. Now, it's not correct in our submission that the Herald transfer somehow, as a matter of law, automatically extinguished Primeo's loss. Just as a reminder, obviously Primeo advanced cash to Bilmis. As part of the Herald transfer, Primeo did not receive equivalent cash back from Bilmis. Rather, Primeo received shares in Herald. And Herald was in turn entirely invested in Bilmis. So in effect, Primeo simply swapped a direct investment in Bilmis for an indirect investment held through Herald. Now, on this point in our submission, the Court of Appeal's analysis at paragraph 221 of its judgment, E263, was correct. They say in 221, we agree with Mr. Smith's submission that the question the judge should have asked was whether the Herald transfer conferred a benefit on Primeo that nullified the losses Primeo had already suffered as a result of the breaches of the duty to keep cash safe, and the answer that should have been given was no, because by the transaction, Primeo did not improve its previous position. Instead, it swapped a direct exposure to loss resulting from the receipt of a shows in action propped up by a Ponzi scheme to an indirect exposure to the same loss. The shows in action now sitting as an asset on Herald's balance sheet, on which the value of Primeo shares in Herald was dependent. Now, we accept there is a different question about whether the value received by Herald pursuant to the Herald transfer mitigated its loss. But that, we've always accepted that, but that is a point which goes to the assessment of damages. And this is no doubt a point which the respondents would want to raise as part of the assessment of quantum, and we accept in principle. Primeo would have to give credit for the benefits it's received, and that is part of the question of quantifying ultimately what the net loss is. Credit would need to be given for the value of the shares in Herald, which were received by Primeo as part of the Herald transfer. That would involve attributing a value to the shares in Herald received by Primeo. And as I say, that will fall to be dealt with as part of the exercise of determining quantum, as part of the further hearing on quantum, which the Court of Appeal indicated should take place. But it's not the case that there's somehow some automatic extinction of the loss. The issue is one of assessment of damages ultimately. The third argument in my learned friend's written case is a point that he pursued, is a point that he didn't pursue orally. It's paragraphs 154 to 156 of his written case. We deal with it at paragraphs 12 and 13 of our reply case. It seems to us to be related very closely to the point I've just been addressing. The argument, as we understand it, is the Herald transfer mitigated the loss of cash. Now, as I say, my learned friend didn't make oral submissions on it. I'm not therefore proposing to make oral submissions on it. Safe to say, we understand it's a quantum argument, ultimately. And as I say, the position is that issues as to quantum on the basis of the Court of Appeal's approach would fall to be dealt with by the Grand Court at the subsequent quantum hearing. So the other argument my learned friend did make oral submissions on was what's called the no immediate loss argument, which is paragraph 157 onwards of his written case, paragraph 14 onwards of our reply case. And this is the argument that the Court of Appeal also erred by holding that Primeo suffered loss each time it remitted cash to Bilmis. So as we understand it, it's an argument that's more focused on timing the time at which it said the loss was suffered. And specifically, the respondent's argument is that Primeo only suffered loss in December 2008, at the time when the existence of the fraudulent Bill-Miss Ponzi scheme was revealed. And that's their written case at paragraph 167. In our submission, this is wrong, and in particular, it confuses the question of when loss is suffered with the question of when it's known by the plaintiff that it has suffered loss. And as we understand it, the crux of my learned friend's point is an argument that it's not permissible to use hindsight in order to ascertain when loss is suffered. So on his argument, if monies are advanced to a fraudulent financial institution and are in fact misappropriated by that institution, then loss isn't suffered until the existence of the fraud is revealed. And then that's the case even if by the time the matter comes to trial, it's clear that the fraud had been carried on throughout the relevant period and the monies had in fact been misappropriated earlier. And now, in our submission, this raises the obvious question, why would you not use the benefit of hindsight to establish the true position? If you know by the time of the trial what has actually happened, then why would you not analyse the position on that basis? Now, as the Court of Appeal pointed out, this particular point was in fact dealt with by Lord Justice Robert Walker, as he then was, in a case called DNB Mortgages against Bullock Lees, which is a case that came subsequent to NICredit. You'll find that in the bundle at 3727.
Sorry,
3727. So it's a decision of the Court of Appeal, Lord Justices Henry and Robert Walker, Mr. Justice Scott Baker. It's one of the sort of chain of cases at that time concerning negligent overvaluations by chartered surveyors. So it's part of a fairly considerable block of authority on concerned with that topic. And the question in this case was when the bank which had advanced the money secured by the mortgage over the property had suffered the loss. So a fairly typical fact pattern in the sense that the bank had advanced monies secured by a mortgage over the property, alleged overvaluation incompetently by the surveyor. The question was, well, at what moment in time had the bank suffered loss? Now, if we go to 3730, in the judgment of Lord Justice Robert Walker, there's a section where he begins by, as the heading suggests, setting out the background to NICredit. He says in this court, as before, the Deputy Judge Council's submissions have centred on the decision of the House of Lords in NICredit. And then he refers to the context in which that case arose. And then, if you pick it up at the bottom of the page, you can see there's then a further heading, NICredit number 2, and he goes on then to deal with what the House of Lords had decided in NICredit. And over on 3731, in the third paragraph, he set out what's referred to as the basic comparison explained by Lord Nichols in NICredit. Thus, typically, in the case of a negligent valuation of an intended loan security, the basic comparison called for is between A, the amount of money lent by the plaintiff, which he would still have had in the absence of the loan transaction, plus interest, and B, the value of the rights acquired, namely the borrower's covenant and the true value of the overvalued property. So, I mean, in essence, not a complicated concept. You look at the cash that's going in one direction, and then you look at the value of the rights which are acquired and which go in the other direction. And the question is, well, does that, quote, basic comparison, unquote, reveal any loss? Now, the valuation of the cash element is plainly very straightforward. The issue which may arise is how you value the rights acquired in the other direction, specifically, in that case, the borrower's covenant. And he dealt with that at 3733 under the heading, the value of the covenant. And you can see at the end of the first paragraph, the second paragraph, he says, NI credit number 2 makes clear that the basic comparison described in the speech of Lord Nichols requires the value of the rights acquired, namely the borrower's covenant and the true value of the overvalued property, but it's not entirely clear how the borrower's covenant is to be valued. It was unnecessary for the House of Lords to go into the point, since NI Credit's borrower was a single asset company and was in default from the inception of the transaction. And then if you pick it up in the final paragraph on that page, you really come to the critical part of the judgment. Now, as is inevitably the case, there is in fact a typographical error in this part of the report, and you will notice that the first sentence in particular doesn't make any sense because there's some missing text. Now, happily, we do have the correct text set out in the judgment of the Court of Appeal, which is at 260. So I'm afraid we have to jump, if I may, to 260 and just pick up the text. And the reason is we were obviously able to supply the Court of Appeal with the correct text, which they then recorded in their judgment. And it's towards the end of page 260. Where Lord Justice Robert Walker says, there is therefore some degree of tension in NI credit number 2 between the approach of valuing the mortgager's covenant as part of a bundle of rights comprised in a marketable security and to be valued as the market would have valued it at the time without hindsight, and the approach of valuing it on fundamentals, that is, on the objective evidence available when the case is heard of the true state of affairs at the valuation date. In NI credit number 2, either approach led to the same results. In this case, the two approaches might lead to different results. So far as they would lead to different results, I consider that the mortgagor's covenant had to be valued on the evidence available to the deputy judge, restricted though as it was to the true facts. So he's effectively identified the issue left unresolved by NI credit and identified the answer exactly to the point as to whether you use hindsight or not. And then he goes on over the page. I think we can pick it up about 4 lines down. An inquiry into the true facts is in line with the conclusion which the House of Lords reluctantly reached in Cartledge and Joplin, that the steel dressers' cause of action had accrued when they were first affected by the insidious disease, even though no one knew about it. Since then, the Latent Damage Act has redressed that injustice. And then he says it's also in line with Lord Nichols' general observation at page 1633D that within the bounds of sense and reasonableness, the policy of the law should be to advance rather than retard the accrual of the cause of action. So ultimately, there is an answer to this point, as the Court of Appeal observed, supplied by the Court of Appeal in England in the DNB mortgages case. In our submission, the approach adopted by the Court of Appeal makes sense. If you're at the stage of a trial, when you actually know the facts, when those are before the court, why wouldn't you use hindsight to identify when, in fact, the loss was suffered? There's no reason why you would effectively perpetuate some fiction which you know not to be the case, that the loss wasn't suffered until some later date. And one might add a further point as well, which is really a point that arises out of the facts of the present case. When Lord Justice Walker identifies effectively the choice arising out of the decision in NICredit, if we just go back to page 260, the penultimate paragraph on page 260, he effectively says that the choice is, well, do you value the covenant as part of a bundle of rights comprising a marketable security, i.e. at the time, or do you value it on the basis of fundamentals, i.e. with hindsight? Now, the concept of valuing on a marketable security makes sense when you're talking about a loan which is advanced to a residential borrower. That's a sort of asset that is capable of being sold in the market. No doubt these days there's securitization structures and so on where people acquire those sort of assets. There is a market in acquiring those sort of interests. Now, in my submission, that point applies with somewhat less force to the chosen action we're concerned with in this case, which is ultimately a right against bill miss to recover whatever the proceeds of the fraud may be. I mean, in terms of identifying that as a chosen action, which you can attribute a value to by looking at the market for that chosen action at the time, it's very difficult to see how that would work in any event. So we respectfully suggest that Lord Justice Robert Walker was right. The Court of Appeal was right in this case, and that is in effect a complete answer to this point. Now, the other point my learned friend made in his oral submissions was to refer to Law Society against Sefton, which I think should be at 4825. Sorry, if we can just go to the beginning of it. Sorry, it's at 4807, the beginning of the report. And this is the decision of the House of Lords in Law Society against Sefton and companies. Now, my learned friend said that this is authority for the proposition that you do not use hindsight to value contingent losses. In our submission, he's wrong about that. And that's not, in fact, what it decides. Now, you can see what the case, in fact, decided by looking at the held part of the head note on 4807. It was a case, in fact, involving the Law Society Compensation Fund, the solicitors' indemnity fund, and the argument was whether the fund suffered a loss when it came under a contingent liability to pay a victim, or whether it only suffered the loss at some time later. And you can see in the head notes, just 4 lines up from the bottom of the page, the holding was that, however, a contingent liability, such as the possibility of an obligation to pay money in the future, was not in itself damage until the contingency occurred. Now, the importance of this is it's concerned with loss in the form of the incurring of a contingent liability. It's effectively concerned with the situation where your loss consists in the fact you have been exposed to the obligation, the liability to pay money to another person. So it's concerned with that specific type of loss. And what it's saying is that where your loss is effectively of that nature, the fact you've been exposed to the contingent liability, then you only suffer loss when the contingency actually occurs. You don't suffer loss where you're simply exposed to the contingency of the liability. Now, in our submission, that isn't the present case. Primeo's loss is not because it has been exposed to a contingent liability. And Primeo's loss is because it's dispersed cash out of its metaphorical pocket and received in return rights against a fraudulent Ponzi scheme. It's not a case where the loss takes the form of a contingent liability. And my learned friend, with respect, is wrong to cite that case as authority for the very broad proposition, for which he did, that you use it. He said, it shows you don't use hindsight to value contingent losses. That's not quite an accurate way of putting it. So, my lords, those are our submissions on the strict liability claim, and essentially we submit that the Court of Appeal was right for the reasons which they gave, and also for those further reasons. Primeo suffered loss at the time. It's straightforward. Cash went out. It received rights of less value on any view against, in effect, a fraudulent Ponzi scheme. Now, ground two is, as I say, the strict liability remittal point, which I've already made submissions on. I took that out of order. So that takes me to additional ground three, which is the administrator breach. And on this, the respondents appeal the conclusion of the Court of Appeal that the first respondent was grossly negligent in performing its duties as Primeo's administrator from April 2005 onwards. As your lordships will recall, the relevance of that is that there is an exoneration provision in the administration agreement, which so the relevant question is not merely whether R1 was negligent, but whether it was grossly negligent.
You said the Court of Appeal, that was the judge's finding
as well. Yes, exactly. So I'm going to say very little about this, in fact, because both the judge and the Court of Appeal agreed that the first respondent had acted in a grossly negligent way during this period. And the respondents are in effect seeking to advance their arguments on the facts, which had been unsuccessful in both courts below for a third time. In our submission, those arguments don't raise any particular point of law or principle. They're rather seeking to attack the findings of the courts below made on the facts. And this is a point my Lord Reid adverted to at the start of the hearing. Of course, the board will, as a matter of settled practice, decline to interfere with concurrent findings of fact, except in very limited circumstances. That's Devi and Roy. It's referred to in Central Bank of Ecuador, which we have in the second supplemental bundle at 159. It's paragraph 4 in Lord Mance towards the bottom of the page, referring to Devi and Roy. And as you'll see from that, the sort of exceptional circumstances one is concerned with are quite extreme, one might say, where there's been a departure from proper judicial procedure and so on. But that is plainly not the case here. It's not alleged that there's been some departure from proper judicial procedure. In fact, the respondents have had ample opportunity to put their arguments on two occasions to both the judge and the Court of Appeal, and they were rejected. Now, just to pick up the points my learned friend did make briefly in his oral submissions, he made a point that he said the judge was wrong in finding that the first respondent was negligent from 1996. In our submission, that's a strange point for two reasons. The first is the respondents themselves accept that the judge made no express finding to this effect. That's footnote 84 of their written case. Your Lordship, the reference to that. It's 2408. But as they rightly say in the footnote, he didn't in fact make a finding to this effect. It's something they argue that was implicit. The fact he didn't make a finding to that effect in our submission is not surprising because it wasn't really and isn't relevant to the analysis. And this leads to my second point, is that the question of the position in 1996 is really besides the point, because the key finding for present purposes of both the judge and the Court of Appeal was that the first respondent was guilty of gross negligence from April 2005. And your Lordship will have seen from the judge's judgment that the key episode which led to that finding was the events that took place in spring 2005, where firstly Ernst & Young had expressed their concerns about Bilmis, about whether the assets really existed, and had expressed the view that they were no longer willing to rely on Bilmis's auditors Freeling and Horowitz. And the response of the respondents to that was to issue the custody confirmation, but without having any confirmation or check that the assets actually existed. And then, in effect, it was grossly negligent for the first respondent to then go on issuing the NAVs based on the circularity of relying on ultimately on its own custody confirmation, or the custody confirmation issued by R2, and that is really the nub of the case on gross negligence. One can understand in our submission why the judge and the Court of Appeal decided that in the way they did, but those are a chain of events that arose in spring 2005. Now, the other point which I do need to correct was my learned friend made some submissions this morning, which we found surprising. He, I think, was submitting that there wasn't any ability to obtain independent verification of assets from DTC, Depository Trust Company, or BONY. In our submission, that is obviously wrong, and you can see that from what the judge did find in the judgment. If I can take you first, please, to paragraph 198. Apologies, 193 on page 111. And if you'll bear with me, I approach this in reverse order. We start at 193 and then we need to go backwards. But if you start at the first sentence of 193, this deals with the failure to recommend. And the subject matter, what the judge said the subject matter of that recognition should have been, was that Bilmis be required to establish a separate account at the DTC and or make use of the ID system, I'll come back to that, and establish a separate account or sub-account at BNY. Now, so far as the ID system is concerned, the judge deals with that at 178, firstly, 101 of the electronic bundle. Three sentences in. On the question of breach, the key issue is whether a reasonably competent global custodian would have made and thereafter continued the appointment without requiring or at least recommending that A, Bilmis establish a separate account with the DTC and or make use of its institutional delivery system, referred to as the ID system, and B, establish a separate account with BONY, in each case for the benefit of the Primeo HSBC group clients collectively. And then he deals at 186 with what the ID system in particular would have enabled. And this, in fact, was the critical point, because as the judge observed in the first sentence of 186, on the evidence, it would have been possible to use the ID system so that Bob Lux could obtain notifications directly from the DTC. And as he explains in that paragraph, the ID system is an electronic communication facility, essentially relating to the making of trades and the settlement of trades. And just picking it up in the penultimate sentence, it could easily have been set up so that Bob Lux would receive a notification directly from DTC as an interested party whenever Bilmus identified part of a bulk trade as being allocated to Primeo. In this way, Bob Lux would receive evidence directly from the DTC confirming that an actual trade has taken place and that securities or cash had been settled into Bilmus's account. I mean, the language of institutional delivery ID system sounds complex. Effectively, it's no more than saying you can be copied into the trade slips and so on that are emanating from the DTC, so that you have a means of obtaining information directly from the DTC as to the fact that genuine securities trading is going on, that the securities genuinely exist. And as the judge says in the final sentence of 106, in this way, Bob Lux would receive evidence directly from the DTC confirming that an actual trade had taken place and that securities and cash had been settled into Bilmus's account. So we were slightly surprised to hear my friend's submissions about that this morning. The judge also dealt, just for your lordship's reference, the judge also did in 187 with how the position in relation to Boney could have been regularised. And if you go over to 108 of the bundle, top of the page, it would have been perfectly straightforward for Bilmus to establish a separate account in its own name designated for each of Primeo and the other Bank of Bermuda clients. Mr. Schwartz, the jointly appointed US banking law expert, confirmed there was no regulatory or practical impediment to setting up both a custody account with Boney and a bank account with JP Morgan in this way. These arrangements would not have interfered with Bilmus's triple function business model, nor would they have necessarily prevented Madoff from defrauding HSBC's clients. However, they would have enabled Bob Lux to confirm that the requisite value of Treasury bills did actually exist at each month end, thus making it much more difficult for Madoff to perpetuate his Ponzi scheme. So that could have been confirmed as well. And ultimately, that's the essence of the judge's findings on breach, as far as the custodian is concerned.
I think it's relevant here to refer also to 185, where the judge makes the same point about DTC. They could have had a segregated account. That would not have been problematic.
Yeah, exactly. So that's the other way. I mean, he effectively says, so as far as DTC is concerned, there's two ways. You either do the sub-account or you do the ID system. So with respect, we submit that the submissions on that point weren't wrong, were incorrect. But ultimately, our point on this, as I say, is that this is an issue which was investigated by the judge. It was also investigated by the Court of Appeal, and they both come to the same conclusion, and there's no basis or reason for your lordships to interfere on what is essentially a finding of gross negligence on the facts. So, my lord, that deals quickly with administrative breach, given the nature of our submissions. I was then going to come to the question of causation, which is bear with me. This comprises within it additional grounds 4 through to 7. And I'm going to deal with, I think, 4 through to 7, essentially in the same order my learned friend did. The respondents advanced 4 separate grounds in relation to this, the grounds 4 through to 7, although my learned friend only pursued 3 of them orally. The first ground, as we understand it, relates to the loss of a chance argument. And in this context, the respondents make 2 points. The first, it said that Primeo should not have been permitted to advance a case based on the custody confirmations at trial. including the arguments as to causation based on the custody confirmations, because this case was not pleaded. And then the second argument is that it said the Court of Appeal erred in permitting Primeo to advance a loss of the chance argument in relation to the chances of obtaining a clean audit opinion from Ernst & Young for the first time on appeal. Now, in our submission, both of these objections are wrong. So far as the position at trial is concerned, there's nothing in the argument that Primeo should not have been permitted to rely on the custody confirmations at trial, including for the purposes of causation, on the basis they weren't pleaded. Now, what the respondents in our submission failed to deal with, and likewise my learned friend in his oral submissions to your lordship, is the timing of the disclosure of the custody confirmations by the respondents. We deal with this in our reply written case at 2330, paragraph 48. And your lordships, I'm afraid we'll have to bear with me because I need to spend a little time on this, given the submissions my learned friend made yesterday. But perhaps if we can start with paragraph 48, which provides a summary. As we say in subparagraph 1, discovery took place over 2014 to 2015. Over 100,000 documents were disclosed. We've subsequently been able to identify 19 documents which you can argue fall into the category of custody confirmations, but none of them are complete, and none of them are identifiable as custody confirmations, and importantly, none of them contain the critical statements attached to them, effectively verifying the existence of the assets of Bilmis. I'm going to show your lordship some examples in a minute so you can see what I'm talking about. What then happened was witness statements were exchanged in March 2016. None of the respondents' witnesses made any reference to the custody confirmations at all, notwithstanding that Mr. Fielding was centrally involved in that episode. And as we say in subparagraph 2, we found out about the potential existence of this material because of material that was received from Ernst & Young Cayman in August 2016. Now, they were the auditors. In August 2016, we obtained some material from them, and one could tell from their audit papers that they had relied on these confirmations, because you could look at what audit evidence they'd relied on, and there were references to these confirmations. Now, that then triggered, understandably, requests for disclosure. And ultimately, the critical confirmations, and most critically of all, the 2005 one, which I'll show you in a moment, were disclosed for the first time on 7th of October 2016. That was 14 days before skeleton arguments were due and were exchanged, and less than 1 month before the trial. Now, there's never been a proper explanation, and this remains the case, as to why they weren't disclosed earlier, or why they weren't dealt with in the witness statements. But the fact of the matter is, probably the most important document in the case, which is the April 2005 custody confirmation we learnt about for the first time on the 7th of October 2016. Now, my learned friend said yesterday, and this is day 3, page 35, line 9 to 10, that the custody confirmation Primeo relied on for 2005 was disclosed on the 31st of March 2015. That is simply wrong. Now, if I can just show you by reference to the judgments, the relevant custody confirmation, and then I'll show you the document itself. If you go firstly to the Court of Appeal's judgment at paragraph 51, it's page 205 of the electronic bundle. And they set out at the top of the page the key document, which is a letter dated the 5th of April 2005, issued by the second respondent to Ernst & Young in relation to the assets on the bill mismanaged account. It was in the following terms. Further to our custodian letter dated February 11, 2005, please find attached additional extract regarding the Primeo account held with Madoff. This extract contains details of the fund's assets held by Madoff. It has been signed by an appropriate signatory of HSSL, the second respondent, and is to be taken into account in conjunction with the original letter of 11th of February 2005. And then what they say is effectively they refer to the attachment, and we'll come to that in a moment, but it was essentially a printout containing the security, well, a purported list of the securities held at Bilmis and signed by an officer of R2 and bearing its name and address stamp. And you see, and this is what we refer to as the April 2005 custody confirmation. It was then relied on by Ernst & Young as audit evidence for the purposes of their audit that these assets actually existed. Now, you also see it, it obviously features heavily in the judge's judgment, but you can see him setting out the text of it at paragraph 107, page 62. He says, the confirmation in respect of Primeo was issued on the 5th of April 2005, but it was not in fact in the standard form. It's a carefully crafted letter which related only to the assets on the bill mismanaged account. Further to our custodian letter dated February 11, 2005, please find additional extracts, same text. And then as he also explains, the attachment comprises a position appraisal report generated from, that's the Accounting and Valuation Department's accounting system. That's a department within Bank of Bermuda. The report reflects the securities held on bill mismanaged account based on the information contained in the trade confirmations received from Bilmis. The confirmation letter was signed by Miss Natalie Baylan. She initialed the attached report and applied HSL's name address stamp. Now, we sent to your lordships this morning, I don't know if they've been received 2 additional documents, just so we can show your lordships what we're actually referring to. Yeah. Do we also want to break at this point?
Yes, I think we might turn to the documents after the adjournment. Now, you've got until about 3:15 this afternoon, Ms. Smith.
Yes, that's
still quite a lot of territory to cover.
We're making reasonable progress.
Good. Very well.